This is file number 255409. Record will reflect Mr. Duvall present here in the courtroom today.
Sierra Coke on behalf of the people.
We do have a resolution of the court in regards to this matter. I've been in discussions with the prosecutor. The agreement is that Mr. Duvall would plead to count one without the habitual offender notice. That would be under a 1 year delay. We're under a delay. I think the statutory max is 1 year. If he's successful on that delay, it would be reduced to the misdemeanor lewd and lascivious conduct. And I have the MCL of that for the court. That's MCL 75335, and that's a 1 year misdemeanor.
Ms. Coke, is that correct statement?
It is, Your Honor. We're asking the court to accept this plea. I did confirm that under the 771 delay, because this is a fourth, it is allowed if the court, feels it meets the statutory requirements. I have reviewed the sexual risk assessment report, and I felt that it didn't.
Hold on a second. Mr. Dan, you're not leaving the courtroom. Mr. Dan, come back. You review that right here. You're not leaving.
Your Honor, I felt that after reading the sexual assessment that it was an appropriate resolution to this matter. I did speak to the victim's mother in this case, and she felt that it was also a good resolution in this matter. So we'd ask the court to accept that. And if the court wants to see the sexual risk assessment or see it at sentencing, I have a copy of it.
So I'd like to proceed with the plea today, but yeah, I would like to review that as part of
Thank you. I will provide it to MDOC, and we can have it turned over with the PSI.
All right. So for purposes of today's hearing, we're taking the plea to count one. So
Correct.
okay, from the back to back.
Yes.
All right. Mr. Duvall, have you had an adequate opportunity to discuss this with Mr. Church?
Yes, sir.
And what we discussed here today, is that the same agreement that we talked about?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Over your hand. Mr. Duvall, are you on any kind of probation or parole, or were you at the time of this incident?
No, sir.
And you understand that if you were to fail to successfully complete this delay of sentence and agreement, that by pleading guilty to this charge, which is fourth degree criminal sexual conduct, fourth degree, the maximum possible penalty that you could face would be up to 2 years and or a $500 fine.
Yes, sir.
With that in mind, what is your plea to that today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to do that by leave, which means you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
Mr. Trish, I'm going to ask that you conduct some questioning of your client this day.
Certainly, Your Honor. Purposes of taking the factual basis, because the victim is a minor, I'm not going to use the names.
Thank you.
Mr. Duvall, on or about January 1st of this year, were you here in Crawford County?
Yes, sir.
And on that date, did you have contact with a minor between the ages of 13 and 16?
Yes, sir.
And on that date, were you rubbing her back?
Yes, sir.
And was that above her clothing or under her clothing?
Under her clothes.
And that rubbing, was that for a sexual purpose?
Yes, sir.
I think that establishes a factual basis.
And that happened here in Crawford County.
Yes, yes, ma'am.
I believe it is established, Your Honor.
Ms. Coe, are the people aware of any threats, promises, or inducements other than what they placed on the record?
No, Your Honor.
Mr. Trush.
I'm aware of it.
Ms. Coe, are the people satisfied that the court has complied with statute and court will limit taking this plea?
Yes, Your Honor.
Mr. Trush.
I'm satisfied.
Mr. Duvall, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. And we'll set this matter for a hearing at a later date, probably at the beginning of September. You're going to meet with the probation department for a pre-sentence report prior to that. And then it's important that you stay in touch with Mr. Trush prior to that date as well. Okay. You know, Mr. Voting, is he appearing by video?
He might be. We tried to get him.
So,
The jail is signed in. Hello, can you tell me your name, please?
Dean Godding.
Okay, got it.
he's in Ingham County's jail, or at least that's where he last was.
Okay. Mr. Godding, are you able to hear me okay?
Yes, sir.
Okay. We're on the record in People versus Dean Godding. This is file number 255427. Mr. Godding's present by Zoom from, is it Ingham County Jail? Is that where you're at, Mr. Godding?
Yes, Your Honor.
Okay, from Ingham County Jail. For some reason, the video is not working, but can't hear Mr. Godding.
Oh, hold on. I think there you go.
Oh, yeah. Okay,
Yep.
good. There we go.
They told me not to touch it, but
Yeah. All right. Just Mr. Godding, if at any point you can't hear us, or you need me to repeat something, just raise your hand and let us know, okay?
okay.
Mr. Trush, can you tell me how we're gonna proceed, Mr. Godding?
Your Honor, I think we're going to need to adjourn it probably for 30 days. The situation here, Mr. Godding has a federal matter that's proceeding sort of parallel to this, which is to say, I think this forms the basis for a violation of his federal parole. From my last communication with him, I'm not sure. It sounds like either the hearing is just about to happen or just did happen. Depending on the outcome of that, though, I've been in discussions with the prosecutor. She may well dismiss our case here, depending on what the feds choose to do. But I would ask Mr. Godding, can you confirm what's the status of the federal case right now?
Well, sir, I thought that's what I was here for today. I had no idea that I was coming before this court. The status is the offer is up to 24 months. And from what I know, I was going to try and see if Crawford County would be okay with me doing a very intensive inpatient program. It's a 1 year program.
I don't want to get into what we're asking for here, because this case may wind up dismissed. But so you have a deal in place. Have you taken it, or are you still waiting to take advantage of that?
I'm waiting to take advantage.
Okay. So I would ask to set it out 30 days. When I contacted Ingham County yesterday, they were not able to facilitate a call. Again, not surprising. I called them, 5 o'clock on Sunday. But I have no doubt that I'll be able to get a call set up with him shortly where we can resolve this.
Okay, Ms. Coe, do you have any objections to that?
No, dealing with the federal system is difficult.
Okay, so I'll set this for another status conference at the court's full motion day in September. So Mr. Godding, we're going to set this case here for another hearing to see what can be worked out between this and your federal case. What was your question?
Just that I was just wondering, am I going to be going back to the county I was in, Newaygo? Because where I'm at, I'm having a very hard time with communicating with anybody from here. I'm on lockdown 18 hours out of the day in this county, and I can't really communicate with. Like Mr. Trush said, I've tried to contact many people, and I'm barely in contact with anybody. I've spoken to my daughter and that's it.
I mean, the short answer to that is the U.S. Marshals are the ones who have you there. We have no idea I have no idea if they're going to move you back or not.
Okay.
So, yeah, I mean, that's outside of my jurisdiction in terms of what the federal officers are gonna do. And it sounds like they've got priority in terms of their custody, so
Yeah.
all I can do is keep this case moving and have it scheduled for another hearing and.
Okay. Mr. Trush, I did send you a request. So I could speak to you via our kiosks. I sent it to the 8383 number.
Okay.
So
Yeah, I did receive that. We're working on getting a call set up.
Okay.
Okay, Ms. Koch, anything further on this file?
No, thank you.
Mr. Trush?
No, thank you.
All right. That's all for today, Mr. Gadding, and we're gonna disconnect at this time.
All right. Thank you.
Thank you.
Time to break this one down. This courtroom session featured multiple cases, each with its own weight, but none more layered than People v. Duvall, where Judge George Mertz presided over a plea agreement that required careful handling. Mr. Duvall pled guilty to fourth-degree criminal sexual conduct with a deferred sentencing arrangement under a 1-year statutory delay. If he completes the conditions successfully, the charge can be reduced to a misdemeanor. This isn't something courts do lightly. Both the defense and prosecution, represented here by Ms. Koch, were aligned on the resolution, and notably, the victim's mother also supported the plea. The court discussed a sexual risk assessment report which Judge Mertz agreed to review more closely at sentencing. It's clear the judge was taking a holistic view, not just the offense, but the defendant's risk profile, the victim's family stance, and the long-term public interest. Mr. Duvall, for his part, was straightforward. During allocution, the questioning was sensitive but thorough. He admitted to having sexual contact with a minor between the ages of 13 and 16, specifying that the contact occurred under the victim's clothing and was done for a sexual purpose. The court emphasized the seriousness of the charge and carefully walked Duvall through his rights jury trial, presumption of innocence, right to remain silent, the whole constitutional toolkit. Duvall appeared calm, respectful, and cooperative throughout, acknowledging guilt without resistance. Immediately following that case, we shifted to People v. Dean Godding, held over Zoom due to Mr. Godding's custody status in Ingham County Jail. This was more of a procedural stop. Judge Mertz granted a 30-day continuance after learning that a federal parole matter was proceeding in parallel and could potentially render the local case moot. Godding was a bit confused at first, thinking the hearing was about the federal case, but once everything was clarified, he raised a legitimate concern. He's essentially in isolation for 18 hours a day and has limited communication with counsel. Judge Mertz acknowledged the issue but gently reminded him that jurisdiction over custody logistics lies with the U.S. Marshals still. The court showed empathy and moved to ensure communication lines between Godding and his attorney remained open. Both the defense and prosecution agreed to the delay. There was also a brief hiccup in courtroom decorum. Someone tried to leave the room mid-hearing, prompting a quick "Mr. Stan, come back" from the judge. It was a blink and you miss it moment, but a good reminder that Judge Mertz runs a tight ship. No drama, just a subtle redirect. Overall, this hearing showcased Judge Mertz at his most balanced, firm where needed, flexible when appropriate. Whether accepting a serious plea or navigating the complications of a parallel federal case, he stayed composed, precise, and respectful to all parties. It was a calm courtroom, but beneath the surface, the stakes were significant, and everyone seemed to understand that. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.